Welcome to Right Hassle Real Estate Rundown, Season 2. My name's Andrew Jones. I'm a partner here at Right Hassle, and I'm joined today by a couple of colleagues. James Frost, who specialises in commercial property development and investment. Welcome, James.
Thank you. Nice to be here.
And we're also joined by my fellow partner, Mike Hiscock, who specialises in construction law. Hi, Mike.
Hello there.
So James, if I can start with you. We're getting quite a lot of inquiries at the moment about clients who are looking to develop commercial property. And I just wanted to have a chat about the top things to think about when developing commercial property. Perhaps we could start with planning.
Yeah, so thank you. I mean, it won't surprise listeners to hear that planning is going to be one of the key considerations when it comes to development of any kind. And clearly that is a good place to start. So will the property need planning permission? Is there an existing planning permission in place? Perhaps it's a planning permission that's in place for a wider scheme. So is it appropriate for the particular development that we've now got in mind? Perhaps there are permitted development rights. If you do need to get planning permission, how likely are you to get it in the context of the property and the surrounding area? And there's a variety of things that we would want to look at to consider whether that is likely to be a material concern when you're planning the design of your scheme.
So if there's an existing planning permission in place, for example, what kind of legal documents might you want to have in place to cover that off?
Well, I think the key role that we will have, in any transaction is to mitigate risk and to identify uncertainty. So I think that you'd want to have a detailed review of what the planning permission is. You would want to consider whether there need to be any changes to the planning permission. There's likely to be a Section 106 to be entered into.
And what's that?
So that's a document that you enter into with the local authority, which very much captures the local authority's agenda in the area. And it's a vehicle for the developer and other interested parties to sort of make contributions and fulfill commitments to the wider area.
Improving the roads or
the
schools
absolutely.
Or something in the area. Got you. Okay, brilliant. So plan's obviously a big issue and can be a constraint to development, but what other constraints do you come across?
Well, the key point here is that you want to get in and have a look at this as early as possible, because a material development constraint is something that's going to potentially run to value of your scheme and bring into question, in a worst case scenario, the viability of your scheme. So we would always hope to get an early look when it comes to considering a property, and we carry out red flag reviews for our clients on a regular basis. The sorts of things that we are going to be looking at: defects on title, there might be restrictive covenants, there might be issues with access, we might have historical title entries that don't bear a modern resemblance to the use of the property and potentially conflict with the sort of intended use. We mentioned planning agreements before, like Section 106s. If you have got a planning permission which is in place for a wider scheme, you'd want to consider whether that Section 106 has the ability to be phased, or whether you would be tied into obligations that relate to a wider scheme, even though you perhaps are only developing a smaller part of it. That can be a significant issue for larger scale developments.
And can that be sorted out contractually between the parties?
It can be, but it's not a straightforward issue. It's not a straightforward thing, because Section 106s are often documents with multiple parties.
Okay.
The landowners are likely to be a party to it. If there are different developers in different parts of the site, you are going to have to be drawing a lot of threads together. So it is a concern for developers when they come across a Section 106 agreement that hasn't been phased, and it's something that you'd want to identify early and do a proper review of the document to establish what exposures you've got, and not only from the obligations that you might have, but the potential for a third party to come in and carry out actions in relation to their property, right, which could have impacts on the land that you're seeking to develop.
Or you need to do something on land that you don't own.
Exactly,
for example.
Exactly.
Yeah.
And it's the sort of thing that you want to find out early so that you can assess, the extent to which it is a material issue. Speaking of third parties, it's very common for third parties to have interest in land, in the land that you either own or looking to develop. That might be in the form of utilities infrastructure. It might be rights of way over the property. There might be occupiers. You might be having to consider how you're going to be getting vacant possession of that property before you can develop it. Do you have the necessary rights for the things that you want to do in relation to that property?
Like access?
Exactly. Access is always going to be the key one. But also, I mean, it's often a really easily overlooked one. Where are you going to be getting your power from? Where's the nearest adopted point for accessing into the power? Where are you draining to?
That could have a huge impact on the viability of the development.
Massive, and it's one of those things that you can easily get caught up in the design of a scheme, and you can make assumptions about how easy it will be to access adopted infrastructure. And we've had it before where we would get into a transaction, and if the necessary due diligence hasn't been done up front, you can suddenly discover that you need to actually put in power across a particular piece of land or put in a pipe across another piece of land, and you don't have the rights to do it. And that can put a block on the transaction. It can waste loads of time. The earlier you find out about these things, the better.
Brilliant. What about environmental considerations? I'm thinking contaminated land or just the energy efficiency of the building that you're putting up.
Yeah, so it's one of those aspects that you would want to consider when doing your red flag review. What was the land used for historically? Is there a risk that a previous use has put some kind of contaminant into the land? Was it former industrial land? Because exactly as you said, the viability that flows from that is going to, there is going to be a question about how much remediation is going to be necessary. And linking back to the planning conversation we had earlier, there's a very high chance that the local authority are going to expect as a sort of precondition to your development that you would carry out all necessary remediation in relation to that land.
And I guess also what the building's going to be like when it's finished, because a lot of occupiers now, that's real high priority on their agendas.
Absolutely, yeah. Forward-thinking developers now are looking to maximise the energy efficiency of buildings, and that forms part, in many ways, of their exit strategy, because they can then market those properties to higher-end investors and to funds who have expectations around the energy efficiency of their properties.
And you mentioned exit there. So once you've got all your ducks in a row and you've built your building, what do you do? How do you get your return?
Well, it's an interesting one, because in reality, you're probably not going to be waiting to the end to be working out your exit strategy. I think a well-advised developer is going to know up front what their exit strategy is. They might even be selling the property up front and then developing it, pursuant to a development agreement that sits alongside that forward purchase agreement. It might be that you've got a institutional fund alongside a bank who are putting money into your development. Whichever way you're planning to fund it, your funder will have an attitude where they are not willing to take on very much risk. They're going to be extremely risk averse, and they're going to have an expectation of you tidying up all of these defects before they're willing to put money in, which makes it that much more important to understand what is there to be dealt with. If you've got a funder on board early, then often you'll be quite hand in glove about that, and they'll have their own representation.
So it's working with them at an early stage and understanding what they want out of the project as much as you want out of it.
Absolutely.
Yeah, great. And construction documents as well. They can be often a very important part of that, which we'll come on to with Mike, but perhaps just touch on that, James.
Yeah, so when you are marketing your property, whether you're doing that at the outset of your development or at the end, if you've been in the fortunate position of being able to develop speculatively, the onward purchaser, funder, occupier even, there's going to be an expectation of reliance on the works that you've carried out, whether that's the actual building works or it might be the remediation that you've done. Okay. So having clarity on the construction and the warranty pack available early on is really important.
Well, that leads very nicely on to Mike, really. Obviously, James has just mentioned some of the construction documents that are important to perhaps end users or investors or funders. But before we get onto that, I'm just interested to hear a little bit more about sort of other legal and regulatory issues that we might have to think about when constructing buildings.
Delivering the design and build phase of a commercial development is complicated, and there are a large number of legal regulatory rules to follow, keeping people safe when they are on site, actually building the building, keeping the environment safe and the surrounding environment, not making any contamination worse, not creating contamination, and following the building regulations. But there are just a couple of points I want to pick out amongst a large number of rules and regulations in this area. Both of them come from the Building Safety Act that was out recently. Yeah. The first point is competency. So there is a much more stringent structure now for making sure that people check whether workers on site are competent to do the work. So it's very, very important where contractors are using a chain of subcontractors, a chain of designers, and perhaps sub-consultants, not just to get certificates and pieces of paper to verify that they've done the work before, but actually to check examples of what they've done, to drill down into how competent they are. Whether they've got a certificate is one step, but if somebody audited that analysis of that supply chain, for example, the HSE came along after an unfortunate problem on site and said, how did you select that subcontractor? The expectation now is that you have drilled down into the competency, the experience, the knowledge of similar projects, so you can explain and justify how you've chosen that particular subcontractor and their competency on site.
So if I'm a developer and I'm about to put a spade in the ground, as it were, how do I go about choosing the right contractor, and also what kind of legal documents can I put in place to protect me?
So the Building Safety Act is one aspect of that. So there will be an expectation that a commercial developer will have looked at suitable people to do their building, to look at their experience, perhaps taken references, looked at examples of other similar jobs that these people have done, and also the robust supply chain that they're using, the experience they're going to be able to draw on.
That can all flow back to the developer?
That can all flow back to the developer. So the developer is looking at a strategy moving forward of who they are going to use and which documents they are going to put in place to ensure that they have got the right people doing the right job.
So what sort of contracts and processes would you normally come across, Mike?
As James said earlier, it's really important to make sure that you've thought ahead about the choice of contract that you're using. Banks, pension funds, freehold investors, major corporate occupiers will all want to see the construction documentation that you are using. So whether that is JCT, which is a very common format, NEC, or perhaps a bespoke document, there will be a process of funders and investors reviewing those contracts. So construction contracts have a very clear payment rules that you have to follow as a commercial developer, with a series of notices that perhaps you or your surveyor or contract administrator will put in place during the project. But also it's about the risk. Who is best placed to carry the risk and how you document that in a contract. So sometimes commercial developers will want to control the design as it evolves during the project. Other times, developers might want to have a lump sum fixed price on a fixed design that they've already created, and they're transferring that across. But in either case, you've got to think about the appropriate construction contract form to use for the particular scenario that you're interested in.
Okay, brilliant. What about design and functionality? Are there any considerations that you think about there?
Design is a crucial part, and particularly in higher risk buildings these days, getting approval for that design from the building regulator can take time, and also your choice of design and functionality is very, very important to maximise the investment potential and the value that you're getting out of your development. So you're thinking ahead about future-proofing the building, you're thinking ahead about not designing for now, but designing slightly into the future. So that your building is flexible for future use and you can maximise the opportunities for occupiers.
Excellent. And really finally, I suppose, I've come across the Party Wall Act. Is that something that you have to think about when you're sort of building a new building, even if it's not necessarily a building adjoining another building?
The Party Wall Act is a common problem that people overlook. It has very specific rules where you are building very close to a neighbouring property, not just the same wall on both properties, but actually if you're within 3 or 6 metres of a property. And the thing to remember about the Party Wall Act is that if you serve notices but you hear nothing back, you can't assume that people are happy for you to carry on. The Party Wall Act has a negative assumption. So a non-response from your neighbour means that they have refused, and you have to get a third-party surveyor in to help you.
Brilliant. Well, thanks both for a really comprehensive rundown in a fairly short period of time. There's lots to think about if you're developing commercial property, so hopefully we can help. Thank you.